When? Okay. Like all right. So, Mr. St. Clair, in cause number 23, DCCR 1390, you're charged with the second-degree felony offense of aggravated assault with a deadly weapon from July 15th of 2023. What that means, sir, is that if you go to trial and you're found guilty, the range of punishment would be between 2 years and up to 20 years in prison. Do you understand? And then in cause number 23, 2117, you're charged with a first-degree felony offense of aggravated robbery from August 15th of 2023. And in that case, what that means is that if you go to trial and you're found guilty, the range of punishment would be between 5 years and up to 99 years or life in prison. Do you understand that as well? And then in cause number 23, 2044, you're charged with a first-degree felony offense of aggravated robbery from August 15th of 2023. Again, that has the same punishment range if you're found guilty, which is between 5 years and up to 99 years or life in prison. Do you understand?
Yeah.
And then finally, in cause number 23, 2043, you're charged with unauthorized use of a vehicle, which is a state jail felony offense. And that is from July 11th of 2023. And what that means in that case is that if you go to trial and you're found guilty, the range of punishment would be between 6 months and up to 2 years in a state jail prison. Do you understand?
Yes.
In each of these cases, I have here on the computer some plea bargain rejections that you have signed with Mr. West that shows that the district attorney's office has made an offer. So is it, what's the?
It would be a 25-year cap in both of the aggravated robberies. We had offered or discussed to dismiss that aggravated assault based on a plea in those ag robberies, as well as the UMB rejected that. We went ahead and did a rejection of a 20 cap in an aggravated assault. But it was my original position to dismiss two, and if he would accept responsibility in the two aggravated robberies, and also not to proceed on his 3 misdemeanors. If I may, just for the record, so Mr. St. Clair is aware, now that he has rejected this, unless circumstances change, which I'll bring to the court's attention well in advance, it will be my position to ask that the sentences run consecutively.
So, Mr. St. Clair, I want to make sure you understand. It looks like what you have signed with Mr. West shows that the state's offer was for you to, if you wanted to enter a plea of guilty to the aggravated robberies, for a cap of 25 years, which means you would be leaving your punishment up to me. I could sentence you to 25. I could sentence you to less. It would depend on the information that was brought to me at a sentencing hearing. And the agreement would have been to dismiss the unauthorized use case, as well as that aggravated assault case, as well as some misdemeanors. If you go forward with trial on these cases, we'll go depending on how this all goes, because the offense dates from the aggravated robberies and they're to the same dates, but then that aggravated assault and the unauthorized use are from a different date. What that means is that if you're convicted on those cases and sentenced by a jury, I could then stack those punishments on top of each other. And I don't know if I would do that or not. It would depend on the information that I saw during those trials. Do you understand? Do you want to reject those offers and have all 4 of your cases set for trial? Pull that down a little bit.
I said I'm trying to get a lower offer.
So here's the thing, we're not negotiating anymore. Okay, the offer, Ms. Malfino just stated that the offer is what the offer is, and unless there is some new information that is received after today, I will not accept this offer after today. So today's the day to either accept this offer, or your cases will go to trial, or it will be to some offer that's different, higher, or to me open, unless there is some, again, new information that no one knows about. And is there any reason to think there would be any new information?
No, Judge, and what my position was in offering the cap that Mr. West and I discussed was to allow Mr. St. Clair to ask the court for probation. I think that's what he's trying to say. That's what he's been trying to say through his attorney. I'm not in the position to offer that. He's been in custody for some time. I think it's been explained to him that the court would take a look at everything and make a determination, but it's not my intention to offer probation, although I'm very well aware of the fact that the court could place him on probation if that's what the court does. We'll respect that decision.
So you understand, if you plead to a cap, I can do, again, anything from probation up to 25 years in prison. I know nothing about your cases at this point. So I don't want to give you some false sense of, yeah, plea open to me and you're going to get a probation. I don't know. You could plea open to, or cap at 25 and I could give you the 25. I could give you somewhere in between. I can consider probation. I just can't know those things but right now, because I don't have any information. And if you did that, what would happen is if you wanted to enter a plea and take that deal, then we would reset your cases for sentencing. We would get a...
I ain't doing this shit I did on now.
Well, if you didn't do it, that's what a jury's for. So we'll get them set for trial, okay? All right, go back with the bailiff. We'll get them set for trial. Sir, you're Daniel Martin?
Yes, ma'am.
And let me get this pulled up. Hold on a second.
If the court's permission, may we proceed on count one only on third-degree arrest?
Yes, ma'am. Okay. And that's 0299, correct?
Yes, sir.
Okay, so Mr. Martin, in cause number 250299, the state's elected to proceed on count one only. It alleges you committed the third-degree felony offense of harassment of a public servant from August 29th of 2024. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily? And because you did what they charged you with? In cause number 250300, you're charged, and we're going on all of them in that, we're going on,
Is that the state?
yeah.
He's playing a 2-year state jail.
So it's state jail only and not the priors in that one?
Let's see what you mean, Judge. The priors would make
Second degree.
on that. That's my error. I didn't flip the page.
That's okay.
Over. I was just
So-
looking at the restitution.
Count one only?
If the court would allow. If not, I'm happy to.
Well, I guess I'll see what happens at sentencing. I mean, what's the agreement?
It's a
2-year
time offer,
state jail.
2 4-year state jail.
Oh,
It's 2 years on that and 4 years on the other.
and the other one, he would be habitual. Okay.
If I need to revisit the
No,
offer,
no. I just need to make sure I'm doing it right. I'm sure, unless you want to revisit it, if you've looked at it and you know what the cases are about, if you're comfortable with going forward with that, that's fine with me.
I am judge of the court is. I
Okay,
think insurance took care of the restitution issues.
okay. So in 250300, the state's also elected to proceed on count one only. In that case, you're charged with the state jail felony offense of criminal mischief from August 29th of 2024. And how do you plead to that charge?
Guilty.
And are you pleading guilty freely and voluntarily?
Yes, ma'am.
And with? I'm sorry.
Yes, ma'am.
In each of these cases, I have here on the computer some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreements that you've made with the district attorney, that you will be waiving or giving up any right to appeal? Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1 in each case.
No objection.
It's admitted in each case. Is there any evidence that Mr. Martin is not competent?
No, Your Honor.
All right, sir, in each of your cases, I'm going to find that you entered your pleas of guilty freely and voluntarily, find that you're mentally competent and understand the nature and the consequences of those pleas. In cause number 250299, find sufficient evidence to find you guilty, and at this time find you guilty of harassment of a public servant. Sentence you in accordance with your agreement to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In cause number 250300, also find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offense of criminal mischief. Sentence you in accordance with that agreement to a term of 2 years in the state jail prison. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These cases will run concurrently, which means together at the same time. I'm going to hand you in each of your cases the trial court certifications that shows these were agreements that I followed, and so you've waived your right to appeal. I'm also going to hand you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Ms. Holmes.
Yes, ma'am.
Good luck to you, sir. You can go back